A leaked US government document sets out a legal justification for President Obama's policy of extrajudicial killing as the UN prepares its own investigation into drone strikes. You're watching Inside Story Americas from Washington. I'm Shihab Rutansi. US President Barack Obama's policy of using lethal force against suspected terrorists is coming under further scrutiny after a Justice Department white paper was obtained by the US media. The document moves the goalposts in regards to when the government is authorized to carry out the killing of a US citizen like Anwar al-Awlaki or his teenage son in Yemen in 2011. Specifically, it broadens the criteria of who might be considered an imminent threat to the United States. Our White House correspondent Patty Culhane has more.
It's been a consistent and unanswered question of the Obama administration. How can they target and kill American citizens far from any sort of declared battlefield without any kind of trial? Well, Congress has been asking for that memo legally justifying the operation, has yet to receive it, but they did get this broader memo. General terms, it says that legally the U.S. can conduct these operations because Congress authorized a war against al-Qaeda, and that in international law, every country has the right to self-defense. Now, the most interesting aspect of the memo, it says that a high-level official in the Obama administration, doesn't specify who, but that person has to believe that the target poses an imminent threat to the country. It goes on to say that they don't have to have actual information about a target or an imminent attack, just that the person is linked to al-Qaeda. How can you possibly explain that apparent contradiction? The Attorney General tried, but didn't.
Some of these things are fact-based, and I can't necessarily get into the weeds or kind of parse these things. You can't, I think, examine these terms without having a reference to the facts. And I'm not in a position in this environment, in a classified environment, I can get more specific, but I'm confident that the definitions that we have used and the explanations that, for instance, that I used in my Northwestern speech are accurate representations of the drivers.
Basically, he was confirming exactly what the administration has been saying since the beginning. Basically, it's classified. Trust us.
Last week, the United Nations announced a major investigation into drone strikes. Led by the UN's Special Rapporteur on Counterterrorism and Human Rights, the study will examine the extent of civilian casualties and the wider consequences of an expanding global drone war. It's estimated that of the more than 3,000 people killed in US drone strikes in Pakistan, Yemen, and Somalia, 500 were civilians. Joining me to discuss this latest information we now have on how the US views its drone strikes and the wider implications are from London, the man leading that UN investigation, Ben Emerson. He's the UN Special Rapporteur on Counterterrorism and Human Rights. From Grand Rapids, Michigan, author Marcy Wheeler. He writes the political blog Empty Wheel. And here in the studio, Joshua Faust, a foreign policy analyst and columnist for PBS. Marcy Wheeler, it might be helpful, first of all, to examine what this white paper is and what it isn't, perhaps. What does this actually represent?
As far as we understand, it is a white paper that the administration gave to the Intelligence and Judiciary Committees last June, so June of 2012, after by now, people in Congress have made 12 different requests for the actual memos underlying the targeted killing program. This is what they got instead. And it's really important to note that we know of another memo. We know of a June 2010 memo that authorizes the targeted killing of Anwar al-Awlaki. There's reason to believe there are more. Senator Wyden from Oregon has been referring to memos plural. But also, at least 12 senators believe that this white paper doesn't reflect what the administration actually believes is the full extent of their legal authorization to kill Americans. And just one example of a question that's been at the forefront of Senator Wyden's concerns for over a year is the administration arguing they can only target Americans based on the AUMF, on the authorization to use military force, or are they arguing, and this seems to be the increasing implication, are they arguing that the president, based solely on his Article 2 authority, can target Americans, meaning it doesn't have to have the sanction of congressional approval that is the AUMF. So there are a lot, I mean, the other really big question that I think most Americans want to know that Senator Wyden believes hasn't been answered is, can the president target Americans here in the United States? That hasn't been answered to his satisfaction.
And actually, Marcy, is it clear, though, which kill program this does actually refer to? Is it, I mean, there are quite a few now. Is it the Pentagon? Is it the CIA? Is it the Joint Special Ops Command? I mean, are we clear about that?
I think that's the problem with this white paper, is it's probably an amalgamation of multiple memos, and it's the administration presenting to Congress what they know Congress won't go crazy having read, and the questions that Congress keeps asking in response are you actually doing this with our authority, or are you doing it based on your own authority? So, I mean, that's why I think 11 senators wrote a letter yesterday to get the actual memos, insisting that they don't know what the administration believes, having seen this white paper, because they suspect, and I think having read the ambiguities in this white paper, I think they've got good reason for it, and I think they probably have a number of other reasons to suspect. They suspect that this white paper is the best gloss of what could be much worse. As bad as this white paper is, I think it's a gloss on what could be much worse justifications to target Americans.
And in passing, Joshua, I mean, this is another leak from the DOJ. I mean, is there an inquiry underway? Are they going to come down hard on the whistleblower for this one, or is this another example of double standards?
I think that remains to be seen. The Obama administration has been pretty vigorous in going after leakers. I think it is really going to come down to whether this is an official leak, which is actually how we know most about the drones program that we know. Or if it slipped between the cracks and it wasn't supposed to be made public.
Ben Emerson, I mean, interestingly, it doesn't seem that this is giving simply a rationale for killing U.S. citizens in drone strikes. It seems to be just a justification for killing U.S. citizens by any means. I mean, is that something that's interesting for you as a UN Special Rapporteur, amongst other things?
Well, obviously, I've read the memo, or the document that's been leaked to NBC. And I've studied its terms, and I've looked at some of the strengths and weaknesses that seem to be evident on its face. But I think we have to be very careful at this point in time before speculating as to what the significance of the document really is. It is a leak. We don't know whether it's a draft. We don't know whether it reflects a final settled policy. And we don't really know what its ultimate significance is. What matters from the
ambiguities on purpose, though, perhaps?
Well, can I say this? I'm not going to get drawn into the detail of the document. For those who are interested in the critique of some of the more obvious points, there's a very clear analysis of it on the ACLU website, pointing out some of the issues that seem to jump off the page.
All right, we'll take those caveats on board. Perhaps, though, we can look in a bit more detail at the sort of principles being outlined in this white paper, whether or not they do constitute active U.S. policy, because certainly they do give us some parameters that are interesting to discuss. Notably, first, the 3 criteria for the legally acceptable extrajudicial killing of a U.S. citizen who's identified as a senior operational leader of al-Qaeda or an associated force. This is what this Department of Justice white paper allegedly says. Firstly, if an informed high-level official concludes that a U.S. citizen poses what it calls an imminent threat of violent attack against the U.S., we'll have more on this definition of imminent a bit later. Second, if the government concludes that capture is not feasible. And finally, that the operation would be conducted under the applicable laws of war. So these are the 3 criteria spelled out in this document, at least, of an acceptable extrajudicial killing of a U.S. citizen by the U.S. Marcy Wheeler, first of all, then, I mean, even at the beginning there, I suppose it's this question of oversight through many of these definitions. For example, how do you decide if someone, and an American citizen in particular, is a senior operational leader of al-Qaeda or an associated force without some form of due process?
Right, and you know, and who chooses this senior administration official? I mean, we all believe that John Brennan has been in charge of this drone program. He's not even Senate confirmed. So if he is the person who is picking and choosing and deciding whether an American counts as a senior al-Qaeda figure, on what basis? And And he's not sharing these decisions with anybody except for maybe the Gang of Eight in Congress. So you've got somebody who's not elected, who's not confirmed, who's making decisions about life and death for Americans. And then there are these terms like, I'm actually really curious what Ben thinks about the use of feasible capture rather than possible capture, because feasible capture ends up being really fluffy. It's something that Senator Wyden has asked about, and it's not even defined in the white paper.
Ben Emerson, is there some international precedent for some of these terms, feasible capture, for example, then?
Well, I mean, that's where the real difficulties start. Because, first of all, I have no doubt that if we were to rifle through the papers that have led to the formulation of the current policy, we would find different formulations and different versions. But far more fundamentally than that, the entire analysis upon which the United States proceeds is not an analysis that is agreed internationally. There is no clear consensus between states or indeed between international lawyers as to what the applicable legal framework is. The US position is one analysis. There are at least two others vying, if you like, for primacy as to what the appropriate rules of engagement are. Now, I entirely understand, both in this program and within the United States, why the focus may be on the powers of the president to take the life of an American citizen. After all, when it comes to legal redress in the US system, it is American citizens who have constitutional rights worthy of protection and not, of course, nationals of other states. But we do need to remember that the vast majority of people who've lost their lives through the use of targeted killing technology are not Americans. They are citizens of different states in which this technology is being used on the sovereign territory of another nation. And there does now need to be, absolutely clearly, with the proliferation of this technology, an immediate and focused debate within the international community in which the United States plays its proper and active part in seeking to achieve a consensus.
But Joshua Faust, I mean, you're very much someone who argues that you don't necessarily have a problem with drone warfare, but you have problems with this so far.
Well, absolutely. I mean, the legal white paper, the way that it is structured and the terms that it's used, I think is deeply problematic. Ultimately, I mean, the way that you describe my views is not really having a problem with drones is because I think, in contrast to Mr. Emerson, I do see them as just one weapon in a very large arsenal that the United States has used to carry out targeted strikes. I mean, the first targeted killing in Pakistan wasn't carried out by a drone. It was carried out by an F-16. American AC-130 gunships, helicopters, and special operations forces have all been used to kill specific people inside Pakistan, including Osama bin Laden 2 years ago. So when we're looking at this policy, I get much more concerned about the policy itself, and rather than the technology used to carry out that policy. Because ultimately, if you start restricting the terms of the technology used, if you come up with some kind of international control regime, the way that there is for, say, ballistic missile technology, there are easier ways, or other easy ways of striking at people beyond just a remotely piloted aircraft. You don't have to rely on a drone to kill people.
This is why
that decision to kill people is what I really get concerned about.
This is why another key part of this white paper is so interesting, is it broadens the idea of what constitutes a threat, specifically the concept of imminent. So let's just read out a portion of the white paper. Quote, "The condition that an operational leader presents an imminent threat of violent attack against the United States does not require the US to have clear evidence that a specific attack on US persons and interests will take place in the immediate future. The threat posed by al-Qaeda and its associated forces demands a broader concept of imminence in judging when a person continually planning terror attacks presents an imminent threat, making the use of force appropriate. Where the al-Qaeda member in question has recently been involved in activities posing an imminent threat of violent attack against the United States, and there is no evidence suggesting that he has renounced or abandoned such activities, that member's involvement in al-Qaeda's continuing terrorist campaign against the United States would support the conclusion that the member is an imminent threat." So basically, there's no requirement to have any clear evidence that a specific attack is being planned. This certainly seems to go beyond what Eric Holder had said in March about the need for an imminent threat of violent attack, but there's a presumption of guilt here. By definition, you're continually plotting attacks if you're part of al-Qaeda and these unspecified associated forces. Marcy Wheeler.
Yeah, I mean, we tried to take al-Awlaki out with a drone strike on 3 different occasions. Once in December 2009, at a time when, according to the intelligence community, we did not believe Anwar al-Awlaki was operational. We came to that belief the very next day with the underwear bomb plot, but the first time we tried to take al-Awlaki out, we thought he was just a propagandist. We tried again in May 2001. We tried and got him in September of 2011. And so you've got a year and a half, 20 months really, elapsing between the attacks that are most directly tied to al-Awlaki's hitting the United States and the time we took him out. In between, you've got the underwear bomber choosing not to plea and not to implicate al-Awlaki. You've got the toner cartridge plot where the informant that the Saudis had there said other figures were more operational, more instrumental in planning that plot. And still another year elapses until we actually go after al-Awlaki. So, I mean, one of the reasons this definition of imminence, and it was, you know, we sort of knew this when Holder made his first speech, that it's very hard to argue that al-Awlaki was an imminent threat, especially in September 2011, after he hasn't been directly involved in an attack on the U.S. in at least a year and possibly 20 months.
And I suppose his teenage son isn't necessarily covered by even by this, though, is it? Necessarily, Mr. Emerson?
Well, no, certainly not. If his teenage son is a non-combatant, can I just come in on a couple of points? First of all, the word imminent appears in a number of legal contexts, in various texts around the world, in various different situations, and it is one of those words that endlessly gets argued about. In terms of what its requirements are. On its normal reading, it requires a short period of time, an immediacy in time terms. But I've seen states argue in a huge variety of contexts, including, for example, public control of public protest, where preventative measures are said to be justified, that the term has a more elastic quality than that. But for me, we can't have a situation where the division between what is lawful and unlawful in terms of the killing of large numbers of people depends upon disputed interpretations of elastic terminology. I mean, let's get it right down to basics here. If the basic United States premise is correct legally, then the United States is at war. And in the course of a war, you do not need to wait until your enemy is pointing a rifle at your head. The aim of war is to kill people. And if the war is lawful, then it is lawful to kill people, even if they are soldiers who are sleeping, or indeed part of the infrastructure for the delivery of basic provisions to enable an armed force to continue. So the real question here is the United States correct to say that under international humanitarian law, interpreted in the light of this developing technology, it can properly claim to be engaged in an armed conflict, either an international or as a party to an internal armed conflict? If that is a legitimate claim in international law, then they're entitled to kill people. The question is, and this is where the real befuddlement seems to cloud the entire debate, the bottom line is that it is not open to one state, in principle, to take its own interpretation of international law.
Right.
International law...
But then this white paper is very clear. Quote, as far as oversight is concerned...
Obviously...
quote, there exists no appropriate judicial forum to evaluate these constitutional considerations, Josh.
Well, that statement is not correct. There are a number of judicial fora in which the issue could arise. It could arise, for example, if Pakistan were to take the United States to the International Court of Justice, as, for example, Israel was taken in relation to the building of the wall. and to seek a ruling from the International Court of Justice as to the legality of the United States actions. But they haven't done so, and obviously one of the questions that we'll be looking at in the course of this inquiry is why they haven't done so. Similarly, in principle at least, it would be open, were there evidence of the commission of a war crime in the sense that there were disproportionate civilian casualties, it would in principle be open to investigation and prosecution as a war crime, either within the United States or under the jurisdiction of the International Criminal Court. But, of course, the United States is not a signatory to the Rome Statute of the International Criminal Court, and in those circumstances it could only be referred to the ICC through a resolution of the Security Council, and being a permanent member of the Security Council, the United States has a right of veto on any such referral.
Joshua Faust, Ben Emerson there was talked about that issue of consent as well, which is very important. And this white paper, again, it seems to be quite, well, I don't know whether it makes the whole notion of consent utterly meaningless. The quote, as far as the consent of other nations to kill people on their soil is concerned, quote, under international legal principles of sovereignty and neutrality, it says the US can attack, quote, after a determination that the host nation is unable or unwilling to suppress the threat posed by the individual targeted. Now, that sense of unwillingness would suggest a lack of consent, and yet that seems to be being taken as a sign that the US does have the legal right to act.
I mean, I think there are two different sides to that. There's another section of this white paper where they also talk about the feasibility of capturing, in the sense of when states don't give consent for there to be a capturing operation. That's been the case in Pakistan. There's a substantial amount of public reporting that suggests the U.S. and Pakistan came to an agreement sometime in 2004 that allows the United States to go after certain classes of targets inside Pakistan. There's a great deal of confusion about exactly what those targets are and what constitutes legitimate targets and illegitimate targets in the eyes of Pakistan. The Pakistani government has collaborated with the United States to capture known al-Qaeda figures. Khalid Sheikh Mohammed is probably the most prominent example. The Pakistani government has also provided intelligence to the United States to strike at insurgents inside Pakistan. So this argument that they have not given consent for these drone strikes is a little
We're not talking specifically then about those cases. We're talking about the formulation in this particular white paper. Marcy Wheeler, if they're saying, look, we can go in even if a host nation is unwilling to kill these people. I mean, again, where does the issue of sovereignty and consent enter into this then?
Well, I mean, two issues. One is, from the consent side, from the American perspective, another really interesting development in the last couple of weeks is that, as far as we know, as of last week, the Senate Intelligence Committee did not know which countries the administration held it could use these lethal counterterrorism operations in. Did not know. Again, Ron Wyden has been asking for this for over a year. So if Congress doesn't know where we're fighting this war that is purportedly authorized by Congress, then how can it be a war that's authorized by Congress? I mean, not even the oversight committees. The other thing is, with regards to the imminence and the question of consent for al-Awlaki, who we believe this white paper to be about, I mean, Yemen also has partnered with us on intelligence to go after these figures. Both Yemen and Pakistan have been incredibly unreliable at times in sending us after their political enemies rather than our enemies. There's, probably good reason to believe that Yemen tipped off Anwar al-Awlaki on numerous occasions when we were about to get him. And after he died, the former president of Yemen actually went to al-Awlaki's family and said, no, I promise I had nothing to do with the strike that took out your son. So there's reason to believe that Saleh, the president, was not willing to take out al-Awlaki for a lot of internal political reasons, even while he was willing to let us operate on his soil. And that's one of the, I think drones are a technology to some degree. Americans need to talk about both drone strikes and paramilitary strikes. There's this international law context, but the other question is, do we actually know who we're hitting? And in both Pakistan and Yemen, oftentimes we don't. We're relying on our allies, on Pakistan, on Saudi Arabia, on Yemen, and they're not necessarily feeding us intelligence that serves American interests. And I think that's one of the things that often leads to a lot of the civilian casualties.
Marcy Wheeler, thank you very much. Ben Emerson, thank you. Joshua Faust, thank you as well.
Thank you.
And that's all from the team in Washington, D.C. for now.